Okay, let us start with our discussions this morning. May I request Miss Rosel, please, to lead us for our opening prayer this morning? Yes, please. Okay, good morning, everyone. Okay, before we formally start with our discussions this morning, I would just like to remind again everyone that today is gonna be the deadline for your compliance with all assignments dito sa ato ang Google Classroom, no? Kasi since as instructed last meeting, last Wednesday, maghulat ko until today para sa mga students nga wala pa nakakomply sa ilahang mga assignments. No, kay since tomorrow is our expected deadline for our midterm grades for cluster 2, no? So, again, please visit your Google Classroom today and check if naka-comply na ba mo sa tanan requirements, no? Tanan required assignments, no? Of course, on top of that, please also communicate with your group mates sa ato ang weekly study outline and check kung naka-comply na ba mo sa tanan weekly study outline so far, no? Para kompleto na pod ang inyong requirements for the midterm grade. Now again, I would just like to emphasize, no, na not complying with all your assignments today will not mean mabagsak mo sa midterm grade. No, that is not the case, but I will be withholding the computation of your midterm grades until such time nga makompleto ninyo og comply tanan mga required outputs, no? Sige, so we are still experiencing unstable internet connections, no? So sige lang. By the way, para sa ato ang recorded discussions last Wednesday, I was not yet able to upload them to the account na kung usually uploadan sa mga recorded discussions because I am still working on fixing my internet connections kaya until karon medyo nagka-problema pa ko, no? Sir, wala lagi kay gi-post nga si sir. Okay. Ang assignments, no, since WF Wednesdays, Fridays man ang atong klase, supposedly, di ba, based on our schedule, I will be posting assignments on a Saturday, no, tomorrow. So, tomorrow pa ko mag-post og assignments. Ina naman ang ato ang nasabutan nga schedule, no, sa first meeting nato sa atong kwan. Okay. Now, last meeting, we discussed... Oh my God, nag-ulan asad. Sige lang. Last meeting, we discussed the nature and effects of obligations, no? Certain topics on the nature and effects of obligations. We discussed specific versus generic things. We also discussed the duties of the debtor, no, and an obligation to give, and of course we also contrasted and compared the three kinds of fruits and kanus pwede mahimong demandable ni creditor ang fruits of the thing, no? Stream connection is not stable. Okay ra ba inyong mga data connections? Okay, medyo unstable ang dinhi sa ako. Sige lang, let's do with what we can. Ako na lang i-off ako ang video ha para di kayo mag-traffic. Okay, sige. So, magklase sa ta karon for the first few minutes, no? But if we see nga medyo dili kaayo nindot atong connection, mag-decide ayon ta later on. Okay? So, our discussion this morning will be a continuation sa ato ang discussion last meeting, no? Last meeting we stopped on the topic on when the obligation to deliver the fruits of the thing arises, no? So kanus pwede i-demand ni creditor ang delivery or ang pag-deliver sa fruits of the thing itself, no? This morning we will start our discussions on the meaning of personal and real rights, no? So we will be comparing and contrasting personal rights from real rights, no? Sige, first off, let us define personal rights or unsa man yung personal right, no? Personal right is the right or power of a person to demand from another as a definite passive subject the fulfillment of the latter's obligation to give, to do, or not to do, no? So ato lang sa sila ipang define for the meantime. On the other hand, ang real right daw is the right or interest of a person over a specific thing, no? Without a definite passive subject against whom the right may be personally enforced, no? So, ang personal right and ang real right has something to do with whether or not na ay passive subject. Na unsa ganining passive subject? Can anyone refresh to the class unsa ganining passive subject? Anyone? Again? Debtor. Obligor, no? So, there is a personal right, no? Ang kana siya nga rights, pwede na nimo i-exercise against a specific person, no? So, sa personal right na ay usa ka definite nga passive subject, no? Or creditor, naa pod isa ka specific na active subject or debtor, no? Whereas sa real right, no, naay usa ka specific nga debtor pero walay specific nga creditor, no? Okay ra ba ako ang kuan? Ako ang voice sa inyo, ha? Okay, sige. Okay, now let us dig deeper with our discussions on the comparison between personal and real rights. No, so first comparison or point of comparison, in a personal right there is a definite active subject and a definite passive subject. No, meaning ang kaning personal right is composed of both the creditor and the debtor. No, unsa may pasabot ana sa personal right, kana siya nga right, no, is only directed towards a specific debtor or a specific person, no? Meaning, for example, kung si person A naghawid og contract, no, wherein ang contract nag-ingon si person B tagaan si person A og kwarta, for example, no? So kana siya nga specific contract, no, only has a specific debtor and also a specific creditor. Meaning, kana siya nga contract, pwede ra na ma-demand ni person A kang person B. No, kay specifically named man si person B as the debtor, no, or the active subject, no? So meaning kana siya nga contract nga gihawiran ni person A, dili na niya pwede i-exercise towards other people. Meaning, for example, kang person C, no? Kay wala man na name si person C anywhere in the contract, no? So ang relationship nga na-enclose in a personal right is only between to specific persons. No, so mao na siya ang first na kaning distinction between personal right and a real right. While on the other hand, in a real right, no, sa atong giingon ganina, there is only one definite active subject pero wala passive subject. Naa lang tay debtor pero wala tay creditor. No? Number 2, a personal right is binding against a particular person, di ba? Kung giingon ganina, no? Ang personal right, pwede ra na nimo ma-demand against a specific person, no? Whereas ang real rights, pwede na nimo ma-demand against anyone in the world, no? So, para mas masabtan na to na, let us take an example, no? So, diri sa libro, ang iyahang gihatag nga example is a classic example of a personal right, a real right, no? Most of the time, no, a real right will also pertain to ownership of real properties, wherein nakay gihawiran nga specific nga title for the properties, no? So sa example, X is the owner of a parcel of land under a Torrens title registered in his name in the registry of property. No? So si person X daw, naa siya'y yuta nga ang titulo nakapangalan sa iyaha specifically. No? So his ownership is a real right directed against everybody. There is no definite passive subject, no? So meaning, so kung bisan kinsa, no, ang mag-claim nga naapod siya right over the same property, no? Bisan kinsa nga tawo ang mag-claim ana, pwede na i-exercise ni person X nga na ako'y gihawiran nga title. No? Ako ang actual nga naay real rights over the said property. No? So anyone in the world pwede to niya i-exercise against anyone in the world kung naa kay gihawiran nga real rights. No? If the land is claimed by Y, who takes possession, X has a personal right to recover from Y as a definite subject, the property. No? So if in case, for example, di ba ganina, ingon ta ang katong parcel of land, actually, panag-iyahan ni person X, no? Pero in the case nga si person Y, i-claim niya ang same property as iyaha, no? And, for example, tukuran niya og balay, no? Kana dayon siya nga case will be a case of a personal right. Unsa man ang personal right, no? Ang personal right ni X is pahawaon si person Y from the land and i-claim niya ang land as his own because again, naa may real right si person X over the property. Okay, now let us move on to the topic on ownership of a thing, no, acquired by delivery, no. So last time sa Article 1164, no, ato ang gi-discuss diri sa Article 1164 last meeting, no. The creditor has a right to the fruits of the thing and the thing itself from the time the obligation to deliver it arises. Meaning, kung kanusa dapat i-deliver ni debtor ang thing kang creditor, ana nga time magsugod ang iyahang rights to demand delivery. No? Rights to demand delivery. No? However, he shall acquire no real rights over it until the same has been delivered to him. No? So meaning, based sa Article 1164, for example, on the day nga pwede na i-demand ni creditor ang delivery of the thing, wala pa siya rights over the thing, no? Dili pa siya ang tag-iya sa thing, ana. So, unsa pa man ang rights, sir, nga naa kang creditor ana nga time? Ang rights nga pwede i-exercise ni creditor at that time is the right to demand delivery. No? So, ayha pa niya ma-consider as owned ang thing kung ma-deliver na sa iyaha. No? So, that's the gist behind Article 1164. No? So the meaning of the phrase, kaninga phrase, gi-quote ni siya from the Article 1164, no? He shall acquire no real right over it until the same has been delivered to him, is that the creditor does not become the owner until the specific thing has been delivered to him. No, sa akong gingon ganina, dili pa ka considered owner of the thing until such time nga ma-deliver na sa imuha. No? So meaning, ang rights to demand delivery of the thing is not equal to rights to own the thing. Okay? Lahi ang ownership actual ownership from the rights to deliver the thing. No? So, let us take one specific example no regarding this article 1164 para mas masabta nato, no? So, S is obliged to give B on July 25 a particular horse. No, so specific and determinate thing, dili siya generic thing, kaya specific man nga horse on July 25. No? Before July 25, of course, B has no right over the horse. No? Kay again based on 1164, ang ownership will only be transferred to the creditor kung ma-deliver na actually sa iyahang specific thing. No? B will acquire a personal right against S to fulfill his obligation only from July 25. Diba? Sa ato ang discussions before, no? Atong discussion on katubit obligation with a suspensive condition, no, or a suspensive period, no? Kung naay condition ang contract, for example, kani siya nga horse, ako lang ni siya i-deliver sa imuha on this particular date, no? So meaning, before that particular date comes, no, dili pwede ma-demand ni creditor ang pag-deliver sa thing. Diba? So ang personal rights ni creditor to deliver the thing will start only on that particular date. Meaning, ana lang nga specific nga adlaw pwede makasugod og demand si creditor nga, oy, debtor, i-deliver na sa ako ang thing kay niabot na ang suspensive period. Diba? So again, ato lang i-refresh no unsa ang definition sa suspensive period or suspensive condition. Anyone? Can anyone recall the definition that we gave for suspensive condition and suspensive period? Anyone? So this is our first question for this morning. Recall, refresh to the class the definition of suspensive condition or suspensive period. Anyone? How about Miss Flores? Miss Flores, what is a suspensive condition or a suspensive period? How about Deb? Do you have any idea with regards suspensive condition? Yes? Sige daw. What is a suspensive condition or a suspensive period? Yes, please. No? So yes, thank you very much. Now, again, ang suspensive condition or a suspensive period is a clause, no, or a term, meaning usa na siya sa nasabutan within the contract, no? Nga until such time nga mahitabo na siya nga condition or moabot na siya nga period, dili pwede mahimong demandable ang obligations nga naa sa contract, no? So that's a suspensive condition or a suspensive period. Okay? So ganina sa ato ang discussion, before the date specified by S and B sa ilahang contract, before ana na time dili pwede ma-demand ni B no nga i-deliver ni S ang particular horse sa iyaha, no? But when the date comes, no, or the suspensive period comes, dinha nga time magsugod ang personal right ni creditor against the debtor to deliver the thing, no? Meaning kung maabot na siya nga suspensive period, naa na dayon personal rights, no, si creditor against kang debtor nga, oy debtor, i-deliver na sa ako ang thing kay niabot na ang atuang suspensive period. Okay? Sige, questions so far? Do you have questions so far? Okay, now let us move forward to the topic on remedies of a creditor in real obligations, no? Under Article 1165. Okay. Now, this is on page 39 sa ako ang books, but I think naani siya sa mga 40 or 41 sa inyo. Okay? Remedies of the creditor in real obligations, no? Before we discuss this topic, let us first understand what the term remedy means, no, in the context of law or in the legal context, no? When we speak of the term remedies in the context of law, ang pasabot ani is ang options, no, or ang courses of actions nga pwede buhaton ni creditor, no, in a real obligation. Again, what is a real obligation? A real obligation is the obligation to deliver a thing, no, to give ni siyang obligation. Okay? So, again, let us recall from our meeting, our discussions last meeting, na we have two types, no, of things, no, nga pwede mahimong object of a real obligation. We have the specific or determinate thing, no, or ang katong specific gyud nga butang nga specifically distinguished from the rest of its kind. We also have this generic thing, no, which is a general description of a thing, walay specifications, no? So let us first discuss unsa ang remedies ng creditor in a real obligation under specific things, no, or if ang obligation is to deliver a specific thing, no? In a specific real obligation, the creditor may exercise the following remedies or rights in case the debtor fails to comply with his obligations, no? So meaning, kani siya na mga rights or kani siya na mga courses of actions, pwede lang ni sila i-exercise ni creditor in the case nga dili mo comply si debtor sa iyahang obligation, no? Sige, the first remedy, demand specific performance or fulfillment of the obligation with a right to indemnity or damages, no? So again, kung just like sa atong discussion before, no, on kadtong juridical necessity, no, nga kung dili ma-comply ni debtor ang iyang obligation under a contract, no, ang first remedy or ang first nga pwede buhaton ni creditor is to demand fulfillment or demand performance, no? To demand performance or to demand fulfillment or delivery of the thing only if possible pa lang, no? But if it is already impossible, no, for the debtor to deliver the thing, of course, ibayaran na lang ni debtor ang economic value sa thing, also with damages. The next, no, na option nga pwede buhaton ni creditor kung dili ma-perform ni debtor ang iyang obligation to give. Demand rescission or cancellation of the obligation with the rights to recover damages, no? So, kung dili na possible para kang debtor ang pag-perform sa iyang obligation, no? Pwede pilion ni creditor nga ilahan na lang i-cancel ang ilahang contract or i-cancel na lang ang obligation ni debtor under the contract. But also, kinahanglan bayaran ni debtor og damages si creditor, no? So kung ma-notice ninyo later on after we discuss the third, no, tanan remedies or actions nga pwede buhaton ni creditor, naa siya right to recover or to be paid damages, no? Kinahanglan gyud kung mao man na siya ang basic na accessory liability ni debtor kung dili niya ma-perform ang obligation, dapat bayaran niya og damages si creditor. And of course, lastly, ang pinaka-last nga remedy ni creditor is to demand payment of damages only where it is the only feasible remedy. What do we mean by the third? No? Kung impossible na, no, meaning dili na gyud ma-deliver ni debtor ang thing ngadto kang creditor, no, for any reasons, or dili possible nga ma-cancel nila ilahang contract, so ang pwede na lang i-demand ni creditor is ang payment of damages, no? But nevertheless, kung bisan asa sa tulo iyang pilion nga remedy, naagid siya always right, no, to recover damages. Mao na siya ang least or minimum requirement, no, kung dili ma-perform ni debtor ang iyahang obligations, kinahanglan niya bayaran si creditor og damages, no? So, mao na to sila ang mga remedies, no, ni creditor kung ang ilang obligation or ang obligation ni debtor is to deliver a specific thing, no? Ato naman na distinguish or na compare ang specific and generic things last meeting. Let us now go to the remedies or unsa man ang pwede buhaton ni creditor kung dili ma-perform ni debtor ang iyahang generic real obligation, no, or ang obligation to deliver a generic thing, no? Let us remember, no, nga ang specific things, no, isa lang yun na siya. Like for example, no, ato ang example last meeting was kining person A is obliged to deliver a specific watch to person B, no? Or person A promises to deliver the watch that he is wearing today to person B, no? Although ang watch is a generic or a general description of a thing, pero since gi-specify man sa obligation nga kana nga watch nga iyahang gisuot karon, no? So that makes the object of the obligation specific, no? In our discussion today, generic real obligation. So the obligation to deliver as a generic thing, no? Bisan unsang relo, no? So that's as a generic thing, no? Any model of car, no? That's a generic thing. No? So, a generic real obligation, on the other hand, can be performed by a third party or a third person since the object is expressed only according to its family or genus, no? So pasabot ani no kung ang obligation ni debtor is to deliver a generic thing, no? Pwede nga dili ma-demand ni creditor si debtor nga siya mismo ang mag-deliver sa thing, no? Pwede ma-involve ang usa ka third person, no? Or any person nga dili included sa contract, no? Kay since wala may specific qualities ang iyahang generic things. So let us now discuss, no, kung unsa ang mga responsibilities ni debtor. Take note nga atong discussion karon is still on generic real obligations, no, or katong mga indeterminate things, no. Unsa ang responsibilities ni debtor in case nga ma-delay niya og deliver ang usa ka generic thing, no? So sa Article 1164, no? Article 1164 states that, no, a fortuitous event does not exempt the debtor from responsibility, no? Before we may be able to understand that, let us first discuss the term fortuitous event, no? A fortuitous event is an event nga wala gi-expect ni debtor o ni creditor and wala sila'y control over, no? Most of the time, kaning mga fortuitous event, ang examples ani kaning mga natural calamities, no? Or any events nga walay control si debtor or si creditor. That's a fortuitous event. No? So if in the case no nga naay nahitabo nga let's say you natural calamity, no, for example nagbaha bakaha, no, nagbagyo, so kana siya nga event dili na pwede gamit as an excuse ni debtor para ma-delay niya og deliver ang iyahang obligation, no. Sir ngano man, what if ang iyahang gihawiran nga butang kay naguba, no? Pero remember that the obligation is a generic real obligation, no? Meaning, for example, if the debtor was obliged to deliver to the creditor any watch, no, bisan unsa lang nga relo, kung ang una niya gipalit para ihatag niya kang creditor is naguba, that does not release the debtor from the liability. Ngano man? Because dili man kato nga specific nga relo ang gi-require sa obligation. No, pwede man niya ilisan og lain nga relo. Kay again, the obligation is to give a generic thing. Okay? Do you have questions so far? Questions? Wala no, medyo lain ang atong internet connection. Sige lang. Let us take 5 minutes of break, and when we come back, let us discuss Article 1166.